It's Maddie with the Innocence Topic, and today we're going to be talking about a very specific criminal case that revolves around the right to privacy of your DNA, and whether or not DNA companies like Ancestry DNA or 23andMe should be giving your DNA information out to the police or other organizations. So previously, we have talked about the beginning of the Innocence Project, the history of wrongful convictions in the U.S., and a controversial Supreme Court ruling on the basis of post-conviction relief and access of DNA, which is very important for the Innocence Project, as that is one of the main things they rely on when picking the cases they'll work on with the goal of exoneration. Today, though, I want to look at one important case. This is the case of Christopher Tapp. In Idaho Falls, Idaho, the summer of 1996, the body of 18-year-old Angie Dodge was found in her apartment after she didn't show up to work. She had been raped and murdered. While the investigation began immediately, months passed before early 1997 when Benjamin Hobbs was arrested in Ely, Nevada, for sexual assault. He was from and in Idaho Falls at the time of the murder, so he and his friends were interviewed in an attempt to build a case against Hobbs. One of the friends was 20-year-old Christopher Tapp, who was a part of the group of young people associated with Hobbs. They were called river rats, who tended to hang out at and around Snake River and along the trails, which wasn't far from Angie Dodge's apartment. It was reported that Tapp and Hobbs had been seen with her at a gathering the night before the crime. Tapp voluntarily spoke with police twice within a few days of each other and scheduled a third interview. Before that scheduled interview, though, his parents hired an attorney on his behalf, and so Christopher failed to show up for the interview. The police went to his house and spoke to Tapp's mother, who said that her son would go to the police station in 2 days with his attorney to answer any questions. Instead of waiting for that third interview, the police returned with an arrest warrant that charged Tapp as an accessory to a felony. Now, to look at those police interviews I had mentioned earlier, I want to preface this by saying police interviews are stressful for anyone, but especially someone who is young, with little understanding of the law, and so much to lose. Usually, it is best to say nothing or very, very little, and especially when you don't have an attorney present. Christopher's story to police changed a lot between interviews. In the first one, he said neither him or Hobbs were involved in Dodge's death. 2 days later, at the second interview, he conceded that Hobbs had killed Dodge and asked him to provide an alibi. And then, after he had been arrested in a third interview, he told authorities that he was with Hobbs when he killed Dodge. Hobbs was angry and thought she was trying to ruin his marriage. During this, there was video recording, and Tapp's attorney watched from another room as police questioned his client. One of those people interrogating him or questioning him was a trusted person of Tapp's, a school resource officer. He entered into an immunity agreement on the terms that he remained honest based off of the previous interviews. The issue comes when DNA tests excluded both Tapp and Hobbs as the source of DNA found on Angie's body. So his story changed again. A different friend had committed the crime. And then it happened again. A DNA test excluded that friend. And so yet another friend he threw under the bus. He said that that friend had done it. But DNA excluded that friend as well. At that point, the immunity agreement was voided. Police pressured Tapp to admit involvement, saying his sentence would be more lenient if he had been in fear of his life. Tapp eventually reported that he had cut Angie after Hobbs threatened to kill him, and within a month of Tapp's initial interview, he had been charged with first-degree murder, rape, and use of a deadly weapon in the commission of a felony. Tapp's attorney tried to exclude the confessions, arguing that they had been coerced, but the presiding judge allowed the majority of Tapp's statements to be used. The police told Tapp that Hobbs placed him at the crime, which was false. That never happened, but as we all should know, the police are legally allowed to lie to you. As the pressure from police mounted, Tapp's claimed involvement only increased. There was a witness that said she had heard Hobbs admit to involvement. Others claimed Tapp was with them at the night of the crime, and it didn't matter. Tapp was sentenced to life in prison on May 28, 1998, just a year and some change after being arrested. Immediately and for years, Tapp fought the conviction and appealed on any and every ground available. They were all rejected, though, despite a 2001 opinion by the Idaho Court of Appeals that determined Tapp's Miranda rights had been violated during many of his interviews. They claimed it was a harmless error. 6 years later, in 2007, the Innocence Project took on his case. The Innocence Project branch was the one in Idaho, so this is not the New York branch that we all know very well. Hairs and other sources of DNA were requested for mitochondrial testing, which eventually excluded Tapp once again. More testing was requested, but a judge refused the request, saying, while DNA testing may be relevant in identifying one of the assailants, such does not make it more probable Tapp is innocent. Regardless of that ruling, they continued to work using mitochondrial DNA and with Idaho Falls police to determine the male lineage that matched the Y chromosome profile found in the evidence. The goal was to find the perpetrator, get the confession that excludes Tapp. Eventually, Angie's mother, Carol Dodge, who had previously requested the death penalty for Tapp, became less and less sure of his guilt. She actually eventually reached out to Stephen Drizzen, an expert in false confessions, who reviewed all the interview material in relation to Tapp, concluding he had been coerced. He was able to involve the New York, or original branch, of the Innocence Project. They requested post-conviction release based on the confessions being coerced. That request would not be ruled on, as in 2017, the county district attorney and Tapp reached an agreement where the rape charge was dropped and the murder conviction was reduced to time served. And so he was released. But for some, the agreement only made Tapp seem more guilty. Specifically, the prosecutor on the case came out and said that it made his guilt seem apparent. The witness we mentioned earlier that said she heard Hobbs admit to murder was recanting her statement upon his release. She had originally said it to Carol Dodge and then later admitted it to Tapp. She said the police threatened to arrest her on drug charges and that she didn't even know Hobbs. After his release, the Innocence Project, Idaho Falls Police, and a tech company called Parabon's Nano Labs worked together to create a DNA profile and compared that to profiles on genetic databases. A family tree was slowly built and narrowed down to around 7 people. Those 7 people were narrowed down further to one man, Brian Drips. He lived across the street from Dodge and was questioned early in the investigation before the police set their sights on Hobbs, then eventually Tapp. They surveilled him for a while before they were able to collect his DNA from a cigarette butt he left on the ground. May 2019, Drips was arrested, interrogated, and he confessed, saying he did not know Tapp and he had acted alone in the crime. 2 months later, his murder conviction was vacated. Christopher Tapp sued Idaho Falls Police and got a settlement of $11.7 million. In less than 5 years after his conviction, sometime in the last few weeks, an unfortunate accident caused the death of Christopher Tapp. But this exoneration does not come without widespread controversy. In 2021, the New York Times published an article titled, "Your DNA Could Send a Relative to Jail" by Raphael Kroll-Zadie, which followed the work of the genealogist who worked with Parabon Nano Labs, the one who had worked on the previous investigation, the FBI, and many different organizations or police departments in attempts to solve many questions, but in particular crimes and cold cases. This article shows many of the positives of genealogy in the justice system, despite the implication based off the title. The issue comes from private companies allowing the police to have genetic information of millions of people. The University of Washington Medical School's Malia Fullerton spoke on the issue, saying, "The ethical challenge is how to balance public protection with individual rights. Should police be able to so easily access databases? Most people say yes, especially in cases of violent crime. But where does privacy get to be overridden?" Arguably, with many previous Supreme Court rulings, to a large extent, public protection comes first. Fullerton says many of these controversies can be addressed with transparency from companies. Transparency, though, does not end in biases in our systems. Forensic databases have more DNA from people of color because those individuals are disproportionately in contact with police and other points in the criminal justice system. In opposition, more individuals of European descent voluntarily submit their DNA to genealogy websites. A study found that 60% of the searches for individuals of European descent will result in third cousin or closer matches, which theoretically allows their identification using demographic identifiers. Moreover, the technique could implicate nearly any U.S. individual of European descent in the near future. Arguably, racial bias is a large part of the privacy concerns with DNA or genealogy. These websites are relatively new. The National DNA Index system has been in place since the late 90s with little to no controversy because the need for public protection overrides the need for privacy. On one hand, some may say that DNA being in the NDIS is different because it doesn't implicate your family tree, or that they lost their right to privacy to DNA because they committed a crime. On the other hand, if you didn't commit a crime, there should be no privacy concern, unless you would cover for a family member who did commit a heinous crime. While the issue comes from privacy concerns, perhaps the controversy comes from the implication that this will most affect white people. Now, this isn't to say the government should have free reign to your DNA. But it's to point out the flaws in our system and the hypocritical notions within our system that say some people don't deserve the right to privacy of their DNA, while others do. People in prison already lose so many rights. The right to basic freedom, choice, life. And we would too say that giving up your DNA as a convict shouldn't be a worry as long as you don't intend to commit any crimes. Why could it not be said the same for people submitting their DNA to websites like Ancestry DNA or 23andMe. Just some food for thought.